Now, the New York Post. Now, this broke, really, I'm looking about an hour and a half ago on Fox. The Justice Department is opening a federal grand jury investigation of former Obama administration officials who allegedly conspired to whip up a scandal about President Trump's purported links to Russia during the 2016 election campaign, the Post has learned. Now, you may recall we initially broke this story on March 3rd, 2017, right behind this microphone and right on this program. I played that on Fox last week. I played the subsequent days when we were on Fox and Friends Sunday, and Pete Hegseth was interviewing me, and then the next day, our buddy Sean Hannity interviewed me. But we broke this story because I had pulled together all these news articles, and it was clear what was going on, obviously without the specifics, but I got close enough. The major legal development opens the door to criminal charges against prominent cabinet members who served then-President Obama, including former Director of National Intelligence James Clapper, former CIA Director John Brennan, and former FBI Director James Comey. It's not immediately clear whether the grand jury would be based heavily in Democratic Washington, D.C. or elsewhere. I would encourage them not to have it in Washington, D.C. Strongly discourage them from doing that. Trump and current DNI Tulsi Gabbard have called for a federal probe into the early days of the Russia collusion probe, dubbed Crossfire Hurricane, though the commander-in-chief himself has acknowledged his predecessor likely is immune from prosecution due to a 2024 Supreme Court ruling on the criminality of official presidential acts. I tell you, I don't understand this. Not because I don't understand the law. I don't understand this. And I hear these legal analysts say the same thing, and I hope the Department of Justice is a little bit more mindful of what the court actually ruled. They talked about the presumption of immunity, but there's not necessarily immunity depending on how this breaks out. And so as they conduct their investigation, I hope they don't leave behind Barack Obama. Barack Obama, even if that is their conclusion, and they ought to have a very open mind about it, still may have information that is critical to the criminal investigation, to the grand jury. So I heard one commentator say today, one of the reporters say, so they likely won't be interviewing them. What does that have to do with anything? Even if the Supreme Court does immunize him, and again, I say that's an open book, they still need to talk to him. They still need to talk to him to find out what other people he discussed. So he better get in front of that grand jury, and he better be questioned. And if he doesn't want to get in front of the grand jury, he better be open to questions. I mean, Bill Clinton was open to questions while he was president of the United States by a grand jury. President Trump had to answer questions in writing, he and his lawyer. There is no way Obama should escape being investigated. None. Now, the president, they write, has accused former officials of a treasonous and seditious conspiracy to undermine his first-term agenda, actually interfering in his election, too, which ultimately led to more than 2 years of leaky investigations before special counsel Robert Mueller turned up no evidence of collusion. Fox News first reported the grand jury investigation, which faces significant hurdles due to statutes of limitation for certain offenses. Once again, this is wrong. Even if you believe there are statute of limitations for certain offenses, you conduct your investigation, you do it fully. It's a criminal investigation. So it's not like here's one law and here's another law and the statute of limitations have run. You have no idea what's run and what hasn't. And you're not required to pinpoint any law that is any part of the criminal code in advance of your investigation. Now, I tried to explain this on Sunday, but apparently some people are slow listeners. Let's see here. I let 2016 Democratic presidential nominee Hillary Clinton off the hook, Trump told Newsmax host Affinery on Friday, referring to the former Secretary of State's possession of classified information on a private home email server. I let her off the hook for what? And then I come in and they did the same to me. The difference is they actually meant it. They hurt a lot of people. And it was all a hoax, and it absolutely was a hoax. And now they have it black and white. No, I think they should pay a price, and so do I. An email released by Gabbard showed that Obama ordered an intelligence assessment that found Russia intervened to help Trump defeat Clinton. Even Gabbard said U.S. intercepts actually showed the Russians expected Clinton to win and held back damaging material on her for later release. And not only that, the assessment said the Russians, of course, were trying to influence the election, but it was having no effect at all. And that they did not try to help Trump. Brennan is believed to be under investigation for allegedly lying to Congress in May 2023 about ex-British spy Christopher Steele's dossier of salacious claims against Trump. All lies, all of it. Brennan told Congress in May 2023 that the CIA was very much opposed to having any reference or inclusion of the Steele dossier in a major intelligence action report, but records show he actually wrote at the time, "I believe that the information warrants inclusion in the Obama-ordered assessment." I think they got that guy dead to rights. That's why they're going to make sure it's not in Washington, D.C. Comey was interviewed in May by Secret Service after posting an image interpreted as threatening Trump, which of course it was, and was accused by Republicans of lying to Congress in 2017. Giving false testimony to Congress carries a penalty up to 5 years, but has a 5-year statute of limitations. Okay, so what? I can come up. You know what, Mr. Producer? I touched on this when I was on with Maria B. Bartiromo, who was fantastic too. And I said, you know, folks, you could look at federal campaign financing laws. They twisted that damn thing inside out like a pretzel and used it against Trump. And his mortgages had absolutely nothing to do with federal campaign finance laws. But they said the fact that he made legal payments and entered into non-disclosure agreements demonstrated that he wanted to withhold negative information, and therefore it was an illegal expense. You know, they had all this weird stuff in mind. Well, let me tell you something. Everybody and anybody who spent any money or provided advice or know-how, an in-kind contribution, to help the Hillary Clinton campaign using the lies about Russia and doing so knowingly, like lawyers, like advisors, like Hillary Clinton, then she would have been violating, and the others, federal campaign finance laws, right? Because they're promoting a lie to influence the election. And they're using money to do it that was never reported as a campaign donation. And others who didn't use money but were providing support, it's an in-kind contribution. So there's a lot of ways this can go. That's why I say statute of limitations. And so you do the investigation. You find out who knows what. You put them under oath for sure. You collect all the documentation. And by documentation, I mean a wide net, including electronic communication, telephonic communication, any kind of communication. You determine whether anything was destroyed, classified information, a violation of the Espionage Act, other information, a violation of the Presidential Records Act, which, you know, Jack Smith tried to criminalize. There's a lot here to investigate.